Hello, everyone. My name is Leah Fowler, and I'm the Research Director and a Research Assistant Professor at the University of Houston Law Center's Health Law and Policy Institute. I am also the editor of the most recent edition of the Control Measures and Public Health Emergencies Benchbook, on which this presentation is based. Today, I'm providing a brief training on court orders for the management of persons with a communicable disease from Chapter 81 of the Texas Health and Safety Code. This presentation is made possible by the generous resources of the University of Houston Law Center and the Health Law and Policy Institute. The Health Law and Policy Institute has been around for over 40 years and is home to one of the nation's leading health law programs. Service is one of our core missions, and we hope you will continue to call on us as a resource. I'm recording this training video in advance because I think it has significant benefits as compared to a live webinar. You can watch it at your leisure, stop the recording as needed, and control the speed of the audio to make it faster or slower depending on your preferences. But please note, though this is a recording, we are always available via email to answer any questions. However, recording in advance has some limitations in a fast-moving pandemic. This is a rapidly evolving situation, and it is important that you stay up to date on emergency orders and state and national declarations. I'll touch in on this issue again in this presentation. So with that said, please take note. Today is Friday, March 20th, 2020, and with that, let's begin. A few matters of housekeeping before we start the meat of this presentation. First, if you do not already have a copy of the benchbook, it is available for download online at the Health Law and Policy Institute's website at law.uh.edu/healthlaw/COVID-19. We are also using the special COVID-19 website to house other resources, anything we develop to assist in pandemic-related legal matters. However, if you'd prefer to email us directly, we would be happy to provide you with a digital copy as well. You can reach out to the Health Law and Policy Institute at healthlaw@uh.edu. A limited number of paper copies are available, and if you are interested in a paper copy, please contact us also via email. Second, please consider this training a starting point and not an end point in your education on the current pandemic and the applicable laws. To the greatest extent possible, I have indicated where you can find information about the topics discussed on the bottom right-hand corner of each slide, both from the benchbook and in Texas statutes. We have also included hyperlinks to the relevant citations in the PDF copy of the benchbook to facilitate your work. I believe this is an additional benefit of the digital version as compared to the paper copy. Third, please be aware that, like I noted before, this situation is changing rapidly. Please look for the latest emergency orders and information on court closures at texascourts.gov and information about declarations and orders from the governor at gov.texas.gov. You will also want to be aware of the measures taking place in your area, as there may be some variation between localities. Finally, if you have any questions about the contents of this presentation, please contact us via email. You can reach me directly at lfowler@uh.edu. To orient you to the presentation today, I'll be skipping the usual introductory content about SARS-CoV-2 and COVID-19 and public health for the sake of efficiency. Instead, I'll jump right into a brief discussion of how public health authority and responsibility are divided in Texas, the role of Texas courts, focusing exclusively in this presentation on orders for the management of a person with a communicable disease, and I will offer a very quick note on preserving confidentiality and leave you with a few concluding thoughts. I'd like to emphasize that this training focuses on individuals. I will not be covering orders for groups, property, or matters involving area quarantine. We also will not cover modification, rehearing, reexamination, or appeal. Please note that there's information on these issues in the benchbook, and if there's interest in additional training modules on any of these topics, please email us and we will expedite the development of those resources. We now switch gears to a quick overview of how public health authority and responsibility is divided in the state. At the top, we have the governor. The governor is responsible for matters like declaring a state of disaster under the Texas Disaster Act. For our purposes today, this is the most relevant responsibility I want to highlight for you. It is important for establishing a public health disaster, which I will soon discuss. But the first health authority we will discuss is the Department of State Health Services. The Department of State Health Services, referred to as DSHS in this presentation, has significant public health authority. Especially relevant, DSHS can investigate disease cases and implement control measures. And, in conjunction with actions by the governor, the Commissioner of the Department of State Health Services can also declare a public health disaster. A public health disaster involves both a declaration of the governor of a state of disaster, as well as a determination by the commissioner that there exists an immediate threat from a communicable disease. This has important implications for Chapter 81 of the Texas Health and Safety Code. As a general matter, a public health disaster may continue for not more than 30 days, but may be renewed. And I'd like to note that it is being reported that this is the first time a public health disaster has been issued in Texas since 1901. That predates Chapter 81 of the Texas Health and Safety Code, which was initially drafted in the 1980s to be more specific. I say this to highlight that we are without clear guidance on some of these issues. However, to the greatest extent possible, I have included additional slides in this presentation to try and highlight where a declaration of public health disaster will impact orders for management of persons with a communicable disease. But before we get to that, I want to draw your attention to one more health authority, the local health authority. And if you're wondering what is a local health authority, under Texas law, it's a person. LHAs are competent and reputable physicians licensed and residing in Texas who serve for terms. For example, in Houston, we have Dr. David Pearce. Notably, the local health authority can also investigate disease cases and implement control measures, just like the Department of State Health Services. I give you this information about key players to help you understand the parties involved in written control orders. Under normal circumstances, when these health authorities, specifically the Department of State Health Services and the local health authority, determine that a control order is needed, they may order an individual to implement specific control measures like quarantine and isolation. In many cases, the individual will comply voluntarily and court involvement is never needed. A brief aside, you may notice throughout this presentation, there will be the occasional prompt to consider emergency orders or public health disasters as you approach these issues. These will appear off to the side in these little text boxes. However, in some cases, individuals will not voluntarily comply with a control order. In those cases, courts will be required to step in. Also, in some cases, like where there's a public health disaster, health authorities will not need to demonstrate noncompliance, so your involvement may come sooner. A perennial question in public health is finding the appropriate balance between the often competing goals of public health and individual liberty. This is no longer a theoretical or academic question. You are going to be asked to strike this balance in real time. But before we get too far down the road of procedures outlined for us in Chapter 81, I want to highlight some key developments that will impact what I'm going to tell you. The first thing I want to draw your attention to are emergency orders. For example, on March 13th, the court issued its first emergency order regarding the COVID-19 state of disaster. In this order, it says that subject only to constitutional limitations, all courts in Texas may in any cases, civil or criminal, do a number of actions, importantly but not limited to modifying or suspending any and all deadlines and procedures. This is in effect from March 13th of 2020 through May 8th of 2020. Please be sure you are acting with the latest information by regularly checking texastowardscourts.gov. The second thing I want to draw your attention to is the impact of a public health disaster on Chapter 81 of the Texas Health and Safety Code. As you do your research while handling these matters, be sure to note when a public health disaster impacts a provision of the statute. I will start with an initial and important example of how public health disasters make things different. First, let's look at a typical process for getting court-ordered management. Looking at this flow chart starting at the top, a health authority will identify an individual and generate written orders for management. In some cases, that's the end of it. In other cases, the individual will not comply. At that point, an application for court-ordered management of a person with a communicable disease will be filed with the court. In a public health disaster, we skip some steps. According to Texas Health and Safety Code 81.083E2, an individual may be subject to court orders if the individual is infected or reasonably suspected of being infected with a communicable disease that presents an immediate threat to the public health and a public health disaster exists, regardless of whether the department or health authority has issued a written order and the individual has indicated that the individual will not voluntarily comply with the control measures. So this is where you get involved. An initial question you may have is who is filing this? If it's filed at the request of the local health authority, it will be filed by a municipal, county, or district attorney. If it's at the request of the Department of State Health Services, it will be at the Attorney General's office, though this would be less common, if at all. A second question you might have is the appropriate venue. The appropriate venue is the district court in the county in which the person resides, is found, or is receiving court-ordered health services, though it may be transferred upon the application upon a showing of good cause. Third, you might want to know what's included in these applications. The application will be styled with the person's initials, and interestingly, though you are preserving some anonymity by styling these with initials, 81.152 requires some fairly identifying information, including the person's name, address, and county of residence. It must also include a statement that the person is infected or reasonably suspected of being infected with the disease that presents a threat to public health, and that the person meets the criteria for court orders for the management of a person with a communicable disease. Here, you'll also need a copy of written orders from the health authority and a statement of noncompliance. But like I noted before, public health disasters can change this. An application for court-ordered management in a public health disaster will look similar, but have two notable exceptions. Here we look again to 81.083E. If there's a public health disaster, you may not have a written order from the health authority, and it does not require a showing of noncompliance, either actual or potential. Now let's talk a little bit about what this timeline looks like under normal circumstances, absent an emergency order or declaration impacting that timeline. If a person does not already have an attorney, one must be appointed to them within 24 hours. The hearing must be set within 14 days, and continuances may be granted by agreement or for good cause. However, given the specifics of SARS-CoV-2 and COVID-19, continuances are likely ill-advised. But while the timeline I just discussed is what happens under normal circumstances, these are extraordinary times, and it may not be possible to strictly follow it. Remember what we discussed earlier, specifically that emergency orders, like the ones in effect, may result in modification or suspension of any and all deadlines and procedures, and I'll use this moment as an opportunity to provide a friendly reminder to stay up to date on emergency orders by visiting texascourts.gov. However, once a hearing is set, the person and their attorney are entitled to notice. This includes copies of the application and written notice delivered to the person in person or via certified mail. As a general matter, a person is entitled to remain at liberty unless they have been appropriately detained. And this may strike you as odd, especially in the event of a highly contagious disease, but there are options here that will likely be utilized. And one of those is a temporary protective custody order. This requires testimony that the application will be filed the next business day and probable cause to believe the person presents a substantial risk to the extent that they cannot be at liberty. Please note that these will terminate at 4 p.m. the following business day if the application is not filed. But if it is filed, it can continue for a reasonable time to make a ruling. And this will require a probable cause hearing. It must be shown that there's probable cause to believe the person under protective order presents a substantial risk of serious harm to himself or others to the extent that the person cannot be at liberty pending the hearing on a court order for the management of a person with a communicable disease, and that the local health authority or department has stated its opinion and detailed basis for its opinion that the person is infected with or reasonably suspected of being infected with a communicable disease that presents an immediate threat to public health. Normally, these must be held not later than 72 hours after the time that the person was detained under the protective custody order. But here's where it gets interesting. Remember when I said public health disasters can change things? This is perhaps where it is most apparent. If the area in which the person is found or the area where the hearing will be held is under a public health disaster, the judge or magistrate may postpone the hearing until the period of disaster is ended. At this point, you may be wondering where the individual will be going. The answer is a designated facility. Not everywhere will be an appropriate place to send somebody with a communicable disease, and the commissioner will designate healthcare facilities throughout the state that are capable of providing services for examination, observation, isolation, or treatment of persons having or suspected of having communicable diseases. This will include some obvious exceptions, like nursing homes. Public health disasters can also impact what facilities can be designated and what treatment can be ordered. If certain conditions specified by statute are met under 81.177, private facilities may be used, and the medical exemptions usually permitted under 81.009 are no longer allowed. A friendly reminder that the first emergency order allows for some flexibility. But let's say we're living in normal times, or perhaps that we're still living in abnormal times, but procedures remain largely unchanged. And we get to a hearing on application for a court order for the management of a person with communicable disease. So, where is this hearing? The answer is any suitable location, though it will likely be at the county courthouse upon request. There's an aspect of this that I believe deserves additional attention given the current pandemic. Namely, that it may also strike you as odd that a person with a highly contagious disease may be present in person for a hearing. You have some flexibility here as well. If the health authority advises the court that the person must remain in isolation or quarantine and that exposure to the judge, jurors, or public would be dangerous, you may order that the person may not appear in person and may appear only by teleconference or other means. However, the means chosen must allow the person to speak, to interact with witnesses, and to confer with their attorney. A few additional things to note. There are certain issues involving transparency that must be preserved, and this includes the fact that these are public hearings that are held on the record. It is my understanding that courts will be equipped to do this, even using video conference. Additionally, in all cases, each element must be proven by clear and convincing evidence, and like we noted earlier, and which may be common in the cases you'll handle, it is possible the person will not be appearing in person, but instead via other means. Please take note that this is not an exhaustive examination of 81.169, so please reference the statute directly for general provisions relating to a hearing. Certain disclosures are also required. At least 48 hours before the hearing, the attorney may request certain information, such as citations, information, justifications, and allegations. The court may admit additional information not disclosed if it will not deprive the person of a fair opportunity to contest it. A person also has a right to a jury. If the hearing is for temporary management, a person can request a jury. If it's for extended management, jury is the default, though it can be waived. As a practical matter, waiver may make sense, especially in counties like Harris County, which will not be calling any civil juries for the remainder of March out of concern for public health. However, if a jury is required and is feasible, the jury can make determinations about whether the person is infected or reasonably suspected of infection and whether the person has failed to follow the orders of the health authority. However, they cannot make findings about the types of services the person will receive. If you're hearing this and thinking, a jury in the presence of a person with a communicable disease sounds risky, please remember that the individual can appear by teleconference or other means. You may recall that we do have an emergency order in place that may result in the modification or suspension of any and all deadlines and procedures. At this time, to the best of our understanding, this does not impact an individual's constitutional right to a jury. However, as a practical matter, individuals may be held in protective custody while waiting for a jury, during which they will likely recover from their illness or expire. Both situations will obviate the need for a jury. So what can happen at these hearings? Well, it could include release, orders for outpatient service, orders for temporary management, or orders for extended management. Let's quickly go through these individually. The court shall deny the application and order release if there is not clear and convincing evidence the person is infected or reasonably suspected of being infected, that they've refused or failed to follow orders, if it's an application for inpatient and presumably not a public health disaster, and that the court determines that the person does not meet the applicable criteria for orders. The court may also order outpatient services. A few considerations here that are worth highlighting. First, if outpatient services are sought, the court will need to designate someone to monitor compliance. Second, please take notice of the requirement that the health authority submits a general program of treatment within 2 weeks of the order. In the case of the current pandemic and our understanding of the course of the disease and period in which an individual is contagious, it is my opinion that orders for temporary management will be the most common. These require clear and convincing evidence that an individual is infected or reasonably suspected of being infected, and as a result is likely to cause serious harm and will continue to endanger the public health. Please remember, it must be for less than 90 days. A quick note on medical testimony. For orders for temporary management, the court may admit as evidence the affidavit of medical evaluation and make findings solely from the affidavit, and this is notably different than orders for extended management, to which I will now turn. An order for extended management requires demonstration of the same elements required for temporary management. The key difference here is that the person's condition is expected to continue for more than 90 days, but less than 1 year. Like I noted before, given the realities of our current pandemic and what is known at this time about the disease, it is my opinion that you're unlikely to be issuing orders for extended management. And as I noted above, competent medical testimony is different for extended management. Please note here that you cannot rely solely on the affidavit of medical evaluation when seeking an order for extended management. So what happens if you issue these orders and the person still does not comply? I've outlined 3 potential situations here, including refusal to follow the health authority's control measure, resisting or evading an order, and assisting a person in those efforts. But please note, if an area quarantine is in place, the penalties are heightened. I will now transition very briefly to a note on confidentiality. Please remember that confidentiality is very important, even in a public health emergency. There are many valuable confidentiality considerations in the statute, especially those applicable to health authorities. But for attorneys and judges, remember to style the cases with the person's initials and not their full name, and that you have the ability to take actions to limit disclosure of medical or epidemiological information before it is entered into evidence or otherwise disclosed. Before we end, I'd like to offer a few parting thoughts on some issues that are important beyond just what to expect with these orders. First, I encourage you to stay informed about the pandemic. It is nearly impossible to avoid news about how this is evolving, so where your schedule permits, stay abreast of state, national, and international information. Also, many peer-reviewed scientific journals and news outlets have dropped paywalls on coronavirus-related news. It is a great time to take advantage of these resources. Second, stay informed about the law. This is likely not an area in which you have much or any prior exposure, and resources including myself and the faculty at the Health Law and Policy Institute are available to help you as we navigate this challenging situation together. And above all, stay healthy. It may be a long time before things return to normal. Thank you so much for watching this presentation. The University of Houston Law Center and the Health Law and Policy Institute are proud to be a resource for you as we navigate Chapter 81. Please contact us with any questions or requests for additional training.